Good afternoon, everyone. My name is Darcy Chemnitz, and I'm the Executive Director of the National LGBT Bar Association. And today we are going to be talking about the U.S. Supreme Court's decision in Gill v. Whitman. This call-in will address the state of redistricting and voting rights, which could not be of more paramount importance in light of today's ugly political realities. Allow me one moment to introduce our speakers in a very brief bio. You may Google, of course, and get more detail on their biographies as we're going forward. But allow me to introduce Laura Brill, who is a partner at Kendall, Brill, and Kelly, LLP. Laura W. Brill is a founding partner at the LA Litigation Boutique. She is a certified appellate specialist who handles a broad array of high-profile disputes. She worked with the Loyola Law School professor Justin Levitt and the NAACP to author an amicus brief in Gill v. Whitford, and also submitted an amicus brief in League of Women Voters of Pennsylvania versus Commonwealth of Pennsylvania, the case that successfully challenged a partisan gerrymander in Pennsylvania. A former law clerk to U.S. Supreme Court Justice, the notorious Ruth Bader Ginsburg, Ms. Brill is a thought leader who publishes and speaks widely on voting rights and other legal issues, and her efforts have helped increase youth voter registration in California. Thank you for that, Attorney Brill. And I will now introduce Attorney Paul Smith, who is the Vice President, Litigation and Strategy at the Campaign Legal Center, and is also a distinguished visitor from practice at Georgetown University Law Center. I'd be very curious how that works out at Georgetown. Mr. Smith has more than 3 decades of experience litigating a wide range of cases. He has argued before the U.S. Supreme Court 21 times. Is that correct, Paul? 21?
Yep.
Including Lawrence v. Texas, very notably, and most recently, he argued Gill v. Whitford. He has also argued numerous voting rights cases, such as Vieth v. Jubilier, I hope I'm pronouncing that correctly, Lulek v. Perry,
versus Jubilier.
Thank you, I got that wrong. And Crawford v. Marion County Election Board, that one I hopefully got right. Mr. Smith previously served as a partner in the law firm of Jenner and Block, where he was chair of the firm's appellate and Supreme Court practice, and co-chair of the firm's election law and redistricting practice. And so that is a very brief intro. I would please like to open it up. Shall we start with you, Paul? And why don't you give us an overview of Gill?
So Gill has been a bit of a frustration for me. I argued the case in the Supreme Court last October. We had a long wait for this decision. It is the third time I've tried to persuade the Supreme Court to hold a partisan gerrymander unconstitutional, and I thought this time I got it right. Maybe, but so far they've kind of punted. We may yet still get the right decision out of them in the case, but the decision we got this week was frustrating. It's a challenge to the Wisconsin Assembly map, which was very severely gerrymandered when the Republicans took over the Wisconsin government in the 2010 election. These kinds of maps are redrawn every 10 years after the census. And they guaranteed themselves a supermajority of the seats in any foreseeable electoral context. Even if the Democrats were to get 56, 57, 58% of the statewide vote, they probably still wouldn't be able to take back the legislature. So we went to work and challenged it. In the past, the issue with gerrymanders has not been that whether they're constitutional or not. They're pretty obviously unconstitutional. They're the use of law by the government to decide in advance who's going to win elections and who's going to lose elections based on the government's preference for different political views, something the government's not supposed to be doing. The problem has always been one of line drawing, figuring out which district maps are sufficiently biased against one political party and in favor of the other that they warrant courts getting involved. And so we, in 2004, in the Vieth case, the the challenge of that this was a challenge was made very clear. We got 4 votes in a challenge to the Pennsylvania congressional district map. 4 votes said we should lose and these cases should never be heard in court. And Justice Kennedy wrote an intermediate, a concurring opinion that said, I don't know quite what the standard is, but I'm not willing to throw these cases all out of court. If somebody comes in with a way to measure gerrymanders that allows us to draw a line between sort of politics as usual and really severe ones, maybe we can do that, and then we can start adjudicating these cases and get rid of this, at least the really extreme cases. And so, flash ahead to the current case. We thought we had solved that problem and met that challenge by coming in with a new technique to measure the degree of a gerrymander and allow it to be compared across time and across the country. And we were able to convince the lower court that the Wisconsin Assembly map was one of the most extreme, most biased maps in the last 50 years in the country. And it was held unconstitutional by that court. And so we get to the Supreme Court. It seemed pretty clear we had 4 votes. It seemed pretty clear they probably had 4 votes. Justice Kennedy was still the middle justice. And mysteriously, 9 months later, we get a decision that all the justices joined, saying that we hadn't satisfied the preliminary hurdle of standing because we hadn't sort of put in evidence of harms to individual plaintiffs who lived in each of the particular places in the map where the gerrymander was executed. You do a gerrymander by packing and cracking the disfavored voters. Either you pack them into a few districts where they have lots of wasted votes for that party, or you crack the rest of them into districts where they only get 45% of the vote and don't get any representation. And so there are places in the map where individual plaintiffs live where, they divided up a Democratic district so it disappeared and things like that. And they said, you can't just kind of come in and sue on behalf of all the Democrats of Wisconsin. You have to go district by district and plaintiff by plaintiff and show individual harm. And so that's what we're going to do on remand. We have the plaintiffs. We can get some more and kind of prove this case at the retail level instead of at the wholesale level, kind of district by district, to establish that we have standing and therefore hopefully reinstate the judgment that the map is unconstitutional. But that's going to take a year or two, and so it's kind of unfortunate. We would have loved to have a clean victory and finally start eradicating this really terrible anti-democratic practice. But we haven't so far. Still working at it. I think I'll stop there for the moment.
Yeah, do you want to take a breath and take a pause? And Laura, do you want to kind of give your top level or 10,000 foot up view of this case, and then maybe we can move to the Maryland matter?
Yeah, sure. So, as I was thinking about getting ready for this call, I was thinking, what can I possibly say that would add to, whatever Paul was going to say, and I think the answer is, not a whole lot. As a very high level thing for people to take away, the standard that the plaintiffs won on in the district court was that the plan have been intended to place a severe impediment on the effectiveness of votes of individual citizens based on their political affiliation. It had to have that effect, and it can't be justified on other legitimate legislative grounds. So that's a pretty stark thing to say about a redistricting plan, and the findings were that all of those criteria had been met, and I think Paul's frustration is entirely correct, because when you read the Supreme Court's decision, it has sort of a what are you looking at us for attitude about it. In the tone in which it was, which it's written, and which I think is I think that's a frustrating tone to be met with after you've met a hurdle of putting in, after a full trial, detailed facts about, the intentionally creating severe impediments to effective voting for the Democrats in Wisconsin. So So that's my big takeaway. I mean, I think there's been some folks may have read the articles in the news, different analyses of the case, and a lot of them have pointed to the concurring opinion that was authored by Justice Kagan, which I do think takes a more hopeful view of what the court might do in the future. And I think one of the frustrations has been that the court has not been willing yet to really specify what the standards are for this type of a claim. If they can find judicially manageable standards, and I think Justice Kagan went through quite a bit of effort to say, well, this is what here are some things to focus on where there'd be the most likely chance of success, including different kinds of representational injury and difficulties that the Democrats may have in organizing as a result of partisan gerrymandering. But I think it's frustrating to go through a full trial, have argument on the merits, and then have a procedural dismissal of this kind.
It was particularly striking the way this went, because Justice Kennedy was the focus of the argument, and he said literally nothing to me for the full half an hour. You would have thought that if he didn't think we had sort of met the challenge and come in with a way of measuring this phenomenon and giving them the tools they need, he would have said something, but he didn't. And the conventional wisdom in the press is that he was the one who couldn't ultimately decide whether we should win or lose. That's why they kind of came up with this standing theory to as a way to temporize it. I have no way of confirming that, but it is the usual assumption that the press is making about what happened here. So in some ways it's a bit parallel to the Masterpiece Cake Shop case, where Justice Kennedy seemed to want to find a way to avoid a big decision on the merits either way.
Yeah, the other thing I would say about that is that one of the things that they say in dismissing on standing is, well, if you're concerned about the statewide impact, then that somehow has more of a First Amendment flavor than just a right to vote and not have your vote diluted flavor in terms of your ability to elect your individual representative. But it seemed to me in reading through the facts that there had been evidence, on that issue, and that
Sure.
Maybe they're just saying, we want this to be so overwhelming that it will, guide the results from that kind of injury.
Right.
As we're talking about individual justices and how they interfaced with orals and their opinions, do we want to say a couple of words about Justice Gorsuch at this point?
Well, I guess it was Justice Thomas said we shouldn't even get remanded. We should just be out of court altogether. He is clearly not a friend of ours on this gerrymandering issue, and he in the oral argument, he had this famous line about his steak rub and how our test was a little of this and a little of that, and his steak rub is turmeric. So we all got to learn what he puts in his steak rub. He's got this kind of folksiness, which is a little bit cloying sometimes, but it's charming in others. So we talked maybe about the Maryland case, Darcy?
Yes, please. Let's
so
not talk about the justices' meals any longer. Gobbledygook, where are the words? I mean, at least with Scalia, there was all sorts of, if you loved words, at least there was words in there rather than recipes. But,
right.
Let's talk about Maryland, sir.
So the weirdest thing that happened while my case, the Wisconsin case, was pending, which was argued way back the first week of the term in October, is that they took a second case for briefing and argument while ours was still undecided. This is something, as Laura knows, they don't typically do. Usually when they have a second case that comes along with the same kind of issue in it, they just hold on to it until they've decided the first case, and then they see how the first case affects the second case. But here, though, they took it, and it must have been because it was a different kind of way of attacking gerrymandering. It's a challenge to the congressional districts of Maryland, or really only one of the congressional districts of Maryland, the one in the far western end of the state, which used to be a Republican district but was redrawn by the Democrats in 2011 to make it a blue district by bringing it closer to Washington. And they were arguing that act of changing it from one kind of district to the other was a kind of First Amendment retaliation that is inherently unconstitutional. And that kind of argument was their way of trying to finesse the whole line drawing problem I was talking about before, because they said, look, it is the deliberate changing of this district in response to the way it used to vote that is the essence of the constitutional violation. And that case was up. And for procedural reasons, the Supreme Court really didn't even address the merits of that way of arguing the case. It was up on an appeal from a denial of a preliminary injunction, which meant that they weren't really they hadn't won or lost on the merits yet. And by the time the case got to the Supreme Court, they said the issue of whether there should have been a preliminary injunction is kind of moot. By the time you would get that, even if you should have gotten it, it's too late for it to do any good for you. You should just go back and have the case decided on the merits in advance of the 2020 election. It's not going to affect the 2018 election. So the whole thing was kind of washed out. And at the argument of that case in March, all the justices seemed to be looking at each other saying, why did we take this case? It was very puzzling, but it also suggested they hadn't really figured out what to do with our case either. So it turned into a bit of a non-event. Does that sound right to you, Laura?
Yeah, I think that sounds right. I think they wanted to dispose of them in similar, comparable ways, and it was there to create some balance of everybody does.
It may have been that they liked that it was a Democratic gerrymander. It's also they clearly were thinking in terms of focusing more on individual district problems. The standing opinion they ultimately all joined in my case, the Wisconsin case, said, let's look at each particular place where the map goes awry. And so the fact that this was a single district challenge may have been initially appealing to them because it had a similar kind of resonance. So that's where we are in gerrymandering. Both cases are still pending back in the trial court and could come back.
Yeah.
They're also.
Can I say a couple words about? Oh, sorry. Can I say a couple words about Pennsylvania though? Because I think that's kind of important as a happier note.
But before we do that, Laura, let me just mention that there is a case from an appeal from North Carolina sitting at the United States Supreme Court, and they will have decided probably yesterday, and will tell us on Monday whether they're going to take that case. It's a challenge to the North Carolina congressional district, so it's possible the issue will still be around and will be argued as soon as the fall back in the U.S. Supreme Court. And we told them we think that they have the kind of individual standing evidence in that case that they said we didn't have in Wisconsin. But let's go to happier news and talk about Pennsylvania, right?
Yeah, so one of the taglines in the announcement for this panel said, that it would cover the future of redistricting, and the thought I had with the Pennsylvania case is that the future of redistricting is, maybe in the states, and the Pennsylvania Supreme Court kind of did the opposite of what the U.S. Supreme Court did in Gill, which was they saw a problem and they actually grabbed it and said we're going to resolve it, and then did resolve it. So the petition, I just wanted to talk about the procedural speed of which they did this and how they did this. The action was filed in June of 2017, and again, this was a Republican gerrymander of the state of Pennsylvania related to the congressional districts, and it was one of the most extreme gerrymanders in the country. The trial court actually granted a stay pending the decision in Gill, and when that went up to the state Supreme Court, which said no, we don't think that we should stay this pending Gill because this is a challenge under the state constitution, so we want this case to go forward. they kept jurisdiction, and then they remanded. This was in November 2017. They issued an order saying we're going to keep jurisdiction and remand for a trial, and we want that trial to be over with findings of fact and conclusions of law by the end of December. So like a little over a month to do a full trial on this issue. The judge made that deadline, and then the Pennsylvania Supreme Court expedited briefing, held oral argument in the middle of January, and issued an order striking down the plan less than a week after that. So they then said, okay, legislature, we want you to take a crack at submitting a new remedial plan. The legislature was not able to do that, and the Pennsylvania Supreme Court created its own plan and ordered the state officials to adopt it. So those new lines will be used in Pennsylvania in the 2018 midterms, and hopefully we'll have fairer elections there as a result.
It was really quite a remarkably quick change in the whole situation in Pennsylvania, which may have real national import because it may very well be a place where the Democrats could pick up 4 or 5 seats in Congress.
And so we'll be hearing about.
I was just going to say, I recommend for anybody on the call to go and look at. You can pull up the Pennsylvania decision. It has all the different maps of the districts, and some of them are just really crazy looking, and in terms of spreading out and having very small places where they could be said to be contiguous, and then the remedial map is very straightforward. Does not go through these kind of manipulations to collect people based on party in the same way.
So one of the questions is whether if the U.S. Supreme Court never gets there, the state Supreme Courts will start following the lead of the Pennsylvania Supreme Court. And I think that most people would say it's going to be relatively rare because state Supreme Courts tend to be very partisan. They're elected often and almost always in often partisan ways. And so it arises, this particular solution is going to be most feasible in places where the politics of the state Supreme Court is different from the politics of the legislature, which happened to be the case in Pennsylvania, but it's not really true very many other places. The other thing that's going to be a solution, though, is the kind of independent redistricting commissions that they have in California and Arizona and a few other places. There's a real strongly growing mass movement to push to take this whole process away from the politicians, and I think that by far the best solution of all is to really have to make this whole process politically neutral. So keep your eye out for that in whatever state you happen to be in. It's on the ballot in about 4 states, including Michigan, this fall, and I think that is a really welcome development.
So let's just look at the national kind of map within a chronology so we kind of know where we're at. So Pennsylvania decided earlier this year. North Carolina will know whether or not it goes up on Monday. And then what's happening we have how many other state lawsuits pending on gerrymandering? And there's another 4 that are out there. Is that right?
There's a couple that have just been filed. The Michigan and Ohio were just filed in 2018 and are just getting going. Challenges, I think, in both cases to congressional districts. And those are the ones I'm aware of. North Carolina, Wisconsin, Maryland, that may be all of them.
Right, so that's the other 5.
Yeah.
And then up to 4 states with it on the ballot for independent redistricting commissions at this year's autumn elections, the midterms. So that's going to be
lots
the
of additional groups out there pushing for that. It's becoming quite a popular subject for citizen activism.
Right. And then Paul, Wisconsin's is remanded, and you're going to be what's the timing on that one?
Oh, we have to talk to the trial court, and that gets to be difficult because you try these cases to 3-judge courts, including a court of appeals judge, and so they're not the easiest. You have to get them together, and they have to figure out what they want to do. But there will have to be some additional evidence put into the record, so it'll take, I would think, at least a year. Hopefully we can get it done in time to get relief for the 2020 election, which is a particularly important one because, at least for legislatures, the legislature elected in 2020 will be redrawing the maps in 2021. So you'd like it not to be gerrymandered itself.
Yeah. Obviously, any gubernatorial election is important to attorneys because, generally speaking, the attorney general race will go the same way or the same party as the gubernatorial winner, and so these are issues that are obviously urgent to us. Sorry, Laura, I interrupted you.
No.
So how much do we want to talk about tech and data as it relates to this issue? Paul, you've argued this on 3 different occasions before the 9 robed ones. How has tech and data changed as you've been arguing against partisan gerrymandering?
Well, one of the themes of my argument is that this is the last opportunity we really need to do something about this problem because it's getting much worse. And the data did show that the 5 most biased maps of the last 50 years were all drawn in 2011, and one of them was Wisconsin. And so the reasons for that are in part tech and data. There is much better software and, even more importantly, much better data about how everyone's likely to vote. But the other reason that may be just as important is that the electorate has changed. It's much more polarized and much more predictable in its voting behavior. There used to be many more people who vote the candidate rather than the party, and that's obviously still true to some extent, but much less. And so gerrymanders, when they're done well now, are much more likely to stick all through the whole decade rather than sort of unraveling as they have in the past. And so those are the themes that I was that we very strongly were asserting to the court, that there's time for a solution. And unfortunately, they didn't give it to us yet, but maybe they still will.
Yeah. These things do have a tendency to, as you said, stick. They stay on. Laura, we want to...
let me... One thing that is interesting that's happening in California relating to, I think we're obviously seeing the same kinds of polarization as are happening everywhere, but at the same time, we're also seeing a real rise in people registering with no party preference. So...
Yeah.
For one of the things I've been doing, and maybe this is what you're trying to switch into, Darcy, is focusing on youth voter registration and especially pre-registration for people before they turn 18. So in California, young people can pre-register when they're 16. The same is true in North Carolina, Florida, Colorado, and there's 13 states total plus D.C. where that's allowed, and in many other states. People can either pre-register when they're 17, or at least they can register as long as they'll be 18 by the election in which they plan to vote. So that creates a lot of opportunity to bring in new voters. And for kids in California who are pre-registering, the majority are registering as no party preference, and there's about a 20% split in favor of the Democrats on people who do register with a party. So it's really a very different, it's hard to know if that's just the most politically motivated people who are registering, but it's interesting. So many people are saying, we're not going with either party.
That's a national phenomenon, people listing themselves as independent, but the political scientists would tell you that most of those people really are either Republicans or Democrats pretty predictably, and so that they're able to still predict in advance that this precinct will go this way based on past voting behavior. They don't really put much stock in registration as an indicator of how you're going to vote. But it is true that I think there's a kind of sense of alienation from the system in that people just don't want to be affiliated with a party, even though they may vote that way all the time. It's great work that you're doing, though, Laura, to get people registered. We clearly need to get more participation into the system, and starting with kids, that's where the need is greatest. So,
yeah, it is.
I want
to. Oh, go ahead, Darcy.
No, go ahead. You answer that one, Laura, and then I'll wait. I've gotten a couple questions here that I want to get to, but we'll have time to get to them. But please answer.
Okay, I did want to say in terms of what lawyers can do, because a lot of lawyers, a lot of people are thinking, well, what can I do? And I'm not everybody can be the one, arguing these very complicated redistricting cases. But what I have found is that most lawyers do not know basic laws about how, what people need in order to register to vote, laws governing how to hold a voter registration drive, and I put myself in that bucket. Prior to this year, I did not know the details of all of those laws. So for anybody who's on the call who has 5 hours instead of 500 hours to devote to this, I can't think of a better thing to do than to learn those laws in your state and tell everybody you know about them and get involved in voter registration efforts, because it's a very we have to change the climate and create better civic participation, and the legal community can really be the epicenter of that, including going and doing voter registration at Pride events, which are happening all over the country this summer.
Right, and I'll just give you a quick rejoinder there, Laura. I believe that the California pre-registration efforts peaked in March at the time that the survivors of the Marjory Stoneman Douglas shooting were organizing the March for Our Lives. So it's my belief that any type of mobilization or activity can help with those kind of pre-registration efforts. Isn't that true?
Yeah, I don't know if they went. There was a big increase in March, but there was also a very big increase in May toward the end of the school year. And in California, we have high school voter education weeks at the end of April and at the end of September, and so I think schools have been using those opportunities more to get the students to pre-register. But it's still that we're still at less than 10% of eligible people pre-registering. So it's better than nothing, but it's frustratingly slow in terms of bringing people in the numbers that we'd like to see.
Right. The LGBT Bar is a supporter of a local effort here in D.C. called the Q Street Group, and they had a consultant in to talk about voter identification specifically as it relates to, say, transgender folks and how to get people out to vote generally. And they educated us at that point in time that to tell people, hey, bring your ID, it's easy. Now, whether or not that's true, I know that we did have our first transgender plaintiff in one of the voting identification cases in Pennsylvania, and I know it's difficult for folks to get name change and to get proper government identification, but wherever possible, of course, we do have to encourage individuals, hey, it's easy, go out there and vote. If not, get your provisional ballot and keep on going. Heck, even RuPaul last week was telling everybody to make sure they got registered to vote. So tell me about your efforts as it relates. So when you went and educated yourself as an attorney, Laura, on how to tell people to get registered, how did you go about doing it? Was it within a partisan context? The LGBT Bar is not partisan. Was it within a partisan context, or how did you locally go about doing that?
Yeah, so it's interesting. I've been doing mostly, but not entirely, nonpartisan efforts, and part of that is because I have seen this absence in the schools in terms of schools really taking advantage of this opportunity to get kids pre-registered to vote. And my feeling was, you really do. The schools should be and need to be nonpartisan as they approach this issue, and the same with educating the legal community. I mean, I think we do want a situation in which as many people as possible are registered to vote and are participating. So, but in some instances, for example, working with pride parades, for example, the thing I've seen both at the schools and beyond is a falling away of the infrastructure for civic education and for including voter registration. So there's just a lot of instances in which you would think it would be easy, but and straightforward, but it's not. And one example is we have um, in Los Angeles and Orange County, the Central District of California does naturalization ceremonies for new immigrants. And in Los Angeles, they were inviting the registrar's office was fully integrated into that process, and came in and distributed forms, and is available to help people fill out the forms. In Los Angeles, for reasons that I still haven't in Orange County, I'm sorry, for reasons that I haven't been able to figure out, the registrar wasn't being allowed to distribute the forms inside the ceremony, and so there was a naturalization ceremony in earlier this year in which only 17 people out of more than 1,000 turned in their registration forms after that event. And the court has since addressed this, but there's all kinds of different just different pockets of possibility where lawyers can have a good positive impact in helping the institutions that they're involved in do these kind of basic, put in place these basic structures to help people get registered to vote. And the way I learned about it was really, I just started reading as much material as I could. I found the relevant sections of the election code and the education code. I put together sort of a PowerPoint so that I could start, talking about this. I started learning about the different ways in which California has, I've started very locally, so I started looking at California, which has the third lowest voter registration rate of any state in the country, which always surprises people. And so, I think part of this is learning all the things you don't know, and that's motivation in and of itself.
Well, it's interesting to me, Laura, that I've been here at the LGBT Bar now for about 13 years, and for about 13 years here we've been working with our sister diversity bar associations like the National Bar, the Hispanic National Bar, National Asian Pacific American Bar, and have hosted call-ins like this about immigration and any number of issues over the last 2 years of crisis. And for years we've been looking for a kind of a cause and effect between our diversity efforts for pipeline diversity and going into high schools and talking to them about becoming attorneys. And of course, if you depends upon the location of the high school whether or not you get a lot of intake. We know for a fact that there is really no good data on whether or not we get more and better diverse attorneys by going into high schools, encouraging them, or going to undergrad organizations and encouraging them into going into law school. But we could certainly affect a major good deed in the world if we could encourage them in those 13 jurisdictions to pre-register. Because I know of any number of diversity efforts that address the pipeline at the high school and undergrad level, and I doubt if any of them incorporate nonpartisan pre-registration language with that. So that's something we can take back to the American Bar Association and encourage our folks to engage in, because there's a definite effect getting those folks registered and getting them voting.
Yeah, that would be a wonderful thing to do. It would be a really terrific thing to do. And beyond the 13 states that allow you to pre-register when you're 16, there are a lot of other states where either all of the senior class or a very substantial number of people in the senior class would be eligible to register or pre-register before they graduate. And so it's just kind of remarkable that infrastructure hasn't been there, and it's going to be a lot of building all around the country to make that happen. So Wisconsin, which was Gill, Gill is Wisconsin. They can, as long as they'll be 18 by the time they're going to offer to vote, they can register. So even in Wisconsin.
Well, I think it'd be a good use of
Good
all
stuff.
of our time. Yeah, to get as many votes out as we can between now and November. I think we're at about 150 days. Is it 20 weeks until the midterms. So let's take this kind of out of mobilization and voting registration. And one question that I received via email from a big supporter of ours is, Paul Smith, what was it like to witness the notorious RBG saying, quote, "Where did one person, one vote come from then?" What was going through your mind? We want to know.
Well, it was just nice to get a little help from her. So that was when Justice Gorsuch was asking me, what basis in the Constitution do we have for the federal courts to be policing this activity by the states? And the obvious analogy was to the one person, one vote cases, Baker versus Carr and others. And she jumped right in there. It was a nice moment.
Were you worried that you were going to be on the receiving end of that question next, or did you know that she was just going to play for time until he answered or did not answer?
Oh no,
right?
She was basically answering the question for me that Gorsuch was asking. She was just wasn't worried. I was pleased.
Indeed. Well, we're very disappointed that we didn't get the answer that you were hoping for. In fact, it looks like we got little answer whatsoever. As you went back in, 3 times was not a charm in this case, Paul.
Not so far. No.
Unfortunately for us. If there is anything either of the two of you would like to add at this point in time, you can make your closing arguments. If there's one pearl of wisdom that you would like to leave with people who are suffering frustration and disappointment in results as it relates to these results, any suggestions to bring us out of our doldrums on this from either of you, Paul or Laura, as we start to close out our call?
I would just say that gerrymandering is one of many problems, all of which can be solved with the right level of political mobilization, and so people just need to get going, and people are. So I think the people can take over this and resolve this and many other problems if they'll just get out there and vote and do what they have to do.
And the only thing
Simple
I'd
enough.
add, I totally agree with that. And if anybody, I've been doing sort of a monthly newsletter about voter registration and have been helping different people connect with different opportunities. So if folks want to get on my newsletter, they can just email me their information.
And then, Laura, why don't we include that in our newsletter? It doesn't go out to all 10,000 emails that we have, but it goes out to, 1,500 or so. So that's a chance for us to try to help some mobilization.
That'd be great.
All right, very good. Thank you so much for your time on a very rainy and very gray, both politically and weather-wise day in Washington, D.C. Thank you both so much for your valuable time. Thank you for words of inspiration, and I guess we'll see you all at the voting booth.
Thanks so much.
Thank you, Darcy.
Okay, bye, Paul.
Thanks, everyone. Bye-bye.
Bye.